I'd like to reconvene the Ways and Means Committee, and by way of an announcement, we had several people who had called, and we requested that they submit written testimony. So I just want to call your attention to the packet that's in your folders, and we received about 40 written comments relative to the bill before us here tonight. So those are in the packets. So we will have before us tonight then House File 950 by Representative Nelson. So the chair moves House File 950, fourth engrossment, be recommended to pass and placed on the general register. And we do have some amendments that I understand are mainly housekeeping, Representative Nelson. So the chair will move the first amendment, the A72 amendment, and if you could explain what that amendment does as we get the bill ready for presentation. Representative Nelson.
Thank you, Mr. Chair and members. And the A72 amendment and the, when we get to it, the A76 corrects it's a technical correction to on line 1.12 of the amendment. It referenced the amendment was drafted. There was an error there. It should have been 256B.0711, and it was printed as .711. And so if that could be adopted. Also, Mr. Chair, that would put it in the line there where it needs to be. But basically, on line 1.12 of the A72 amendment, the A76 amendment corrects that.
Oh, that will correct it.
That'll correct it.
So then we will move the amendment to the amendment. That's in the packets as well. Okay. So the chair moves the A76 amendment to the A72 amendment. And that corrects that error. Okay, any discussion? Seeing none, then all those in favor signify by saying aye.
Aye.
Opposed? Motion carried. Now we have the A72 amendment before us as amended.
And Mr. Chair, the A72 amendment is basically technical in nature. There's no substantial changes in language or policy. It was done mostly to help reduce the cost and bring the fiscal note down. And so I'll walk through what the A72 amendment does. On line 1.12, those that were clarifications that whose responsibility is for collecting the dues, and that was requested by the Department of Health and Human, or DHS. And line 1.1 or 1.3 of the amendment, it corrects an error in the election language. Since where Peller is doing a representation election refers to when you're changing unions that are going to be doing it, and they're changing to a certification election, which is what this would be doing, is an election for certification of a union or of a representation as opposed to changing representation. Line 1. Let me get down here. 1.14 is a purely technical. It corrects and references, and it was due to a drafting error. Line 1.17 is it pushes back the I can't even say the word tonight, implementation date 3 months in hopes to reduce the cost, and that was again part of the the purposes of the amendment. Line 1.8 is the second part of, and the second part of line 1.10 were again requested by DHS, and this shifts the responsibility for dealing with the exclusive representation, or is that representative with regards to the bargaining unit list, to the BMS, Bureau of Mediation Services. Line 1.9 in the amendment, it's the first part of line 110 clarifies how many times the exclusive representatives can request the bargaining unit list. Again, these were requested by DHS. Line 1.18 adds a reference to the Development Disability Waiver Program, and that again was requested by DHS. Line 1.19 clarifies that the definition of a covered program that is currently intended to include the list of programs. Line 1.20 and 1.21 clarify the direct support services do not include work done by an independent contractor, such as lawn mowing, snow shoveling, those type of things. Line 1.22 to 1.25 clarifies the question of current employer for the covered workers. If they work at the home of a home care worker and are controlled hour to hour by the agency, they are not in the bargaining unit. But if they work is under the hourly control of the program participant, then they are not agency employees and are covered by this bill, regardless of what program they are employed through. Line 1.26 to 1.27, again, are purely technical and ensure the participants' representatives can participate in the Workforce Council. Line 2.1 to 2.13 simply clarify how DHS should implement the program with regards to clarifying who is and is not part of the bargaining unit. Lines 2.14 to 2.16 are again an attempt to reduce the cost of the worker organ orientation by pushing back the implementation date and clarifying the frequency. Line 2.17 makes the training permissive on DHS's part as opposed to prescriptive, again in an attempt to bring down the fiscal note. Line 2.18 makes the creation of the registry permissive rather than prescriptive again. Lines 2.19 to 2.22 are tried to zero out the cost of training in the registry in this biennium by saying that DHS doesn't have to do these things unless they are both in a contract and the legislature appropriates the money for this purpose. Line 2.23 again is purely technical. Line 2.24 and 2.31 removes the references to entities contracting with the state to simply those who are serving as payroll agents who we learned are not actually under contract with DHS. Line 2.33 and to 3.4 simply clarifies the treatment of data on home care workers. Line 3.5 to 3.7 clarify the lists I can't even say the word, must begin immediately, compiling the list must begin immediately on following the day following enactment. And lines 3.8 to 3.15 are subject of lines that was requested by DHS, again, to clarify the process for dues and fair share deductions, though they have not been vetted with this specific language, so this is what it was done for. So with that, Mr. Chair, I'll answer questions.
Okay. Any discussion on the amendment then as amended? Representative Anderson.
Thank you, Mr. Speaker, or Mr. Chair. Representative Nelson, kind of walk me through a little bit more. I'm looking at page 3 of your amendment on line 9, and also, and actually I want to start actually with page 2, line 33, going through page 3, line 4. Tell me exactly what are we doing here? Are we opening this up so that unions are going to have access into personnel data? What exactly does this language do? Can you help me out?
Mr. Chair and Representative Anderson, it actually does just the opposite. It's the only list information they're going to get it is about the names of the people and not personal data about those people.
Well, Mr. Chair and Representative Nelson, what happens if an individual doesn't want to be identified as a personal care attendant? What kind of safeguards do you have against that?
Representative Nelson.
Well, Mr. Chair and Representative Anderson, they would be, I guess, I'll ask for help here.
If you could identify yourself for the record. Did you hear the question?
Yes, my name is David Zaffron. I'm with SEIU Healthcare Minnesota. The purpose of the bill is to allow those individual providers of these services to have the ability to choose whether or not they would like to form a union.
Mr. Chair and Representative Nelson, my question is, what happens if you have a PCA who does not wish to have themselves identified and put on this list? What options do they have?
Representative Nelson. for Mr. Zaffron.
They can decline.
Mr. Chair, Representative Nelson, can you point to me where in the language it says that they can decline?
They can decline to be contacted, but they cannot be declined to be part of the bargaining unit.
So they have no choice whatsoever, Mr. Chair, Representative Nelson.
Mr. Chair, Representative Anderson, if the bargaining unit is declared and if it is certified, then they're working in that, they'd be part of the bargaining unit. And they can decline to be contacted and they can decline to join the union, but they're still part of the bargaining unit.
Mr. Chair and Representative Nelson, this seems like a pretty significant amendment that you're offering here. Have you talked to any of the providers at all? Have you gotten their feedback on this at all?
Representative Nelson.
There's no change in the
Mr. Chair and Representative Anderson, this is not changing the intent of the bill. This is just clarifying that these people what information will be given as part of the organizing process. And it's no different than regular, it's state, but it's just no different than regular PELRA law. How if there's going to be a bargaining and organized, it would follow those same procedures.
Okay. Mr. Chair, and I appreciate hearing, I mean, this is much more significant than what I was initially told it was going to be. Do we have folks that represent the PCAs that could come down and talk a little bit about this and what this means for their employees, and if they have any other comments on the rest of the amendment? Anybody from the PCA group that can come down and speak to this?
We do entertain, I should have mentioned this because we have some new people here. We don't take general testimony, but committee members can ask somebody in the audience a question. So you look like you were coming forward to respond?
Yes, sir.
Okay, and if you could then identify yourself for the record.
Mr. Chair, committee members, my name is Kara Benson. I work for AcroCare. I'm a program director. In speaking to some of our PCAs, they have disclosed a desire to not be included on this list. There is a fear that individuals, particularly relatives who may happen to live with the recipient of services, that their information could also be disclosed and in the same way that their own personal information can be disclosed. And they have indicated to us that they do not wish that to happen.
Mr. Chair,
Anderson.
Ms. Benson, can you tell me how many of the personal care attendants are actually caring for their own relatives out of the PCAs that you have?
We have a few different statistics, and if I might call on one of my, pardon me? 45% is what we've been.
Okay. Thank you, Ms. Benson. I appreciate hearing that. So, Representative Nelson, so of those 45% of PCAs, personal care attendants, that are caring for their own family members, would they be required to join the union or pay fair share union dues?
Representative Nelson.
Mr. Speaker, Mr. Chair, and Representative Anderson, if the unit is certified, and that's a big if the unit gets certified, then they would be part of the bargaining unit. Right. And like in any other public employee bargaining unit, they would either have to join the union or be required to pay fair share dues.
And Mr. Chair and Representative Nelson, do you have any estimates on what the union dues would be? You know, I've heard some statistics of what it is in other states. Can you give me an idea of what the union dues would be here and what the fair share amount would be under this?
Representative Nelson.
Mr. Chair and members, the dues haven't been set because there isn't a bargaining unit, and like all unions, they set those, the union itself, the members of the union, by democratic vote, set their dues. There's been some talk of $25, $30. I don't know what statistic you have from other cities or states that have done states that have done this. The fair share dues are, by law, under PELRA, can be no greater than 85% of what the regular union dues are. And again, they can be no more than 85% of the normal dues. Now, that's a figure that's set yearly based on the expenses of the union of what they spend their money on, because fair share dues cannot go for organizing purposes. They cannot go for political purposes. They just go for the representational part of the costs that are associated with that. And that's set by the figures that they turn into the National Labor Relations Board every year when they fill out their LM2s, the LM1s, depending on the size of the union. But then when they fill those forms out, it's broken down into percentage they spend on these things, and they could only charge for the representational parts of what the dues go to. So if it was 90%, the most they could charge is 80% or 85%. If it was less than 85%, that's the largest amount they could charge.
And Mr. Chair and Representative Nelson, what is the typical? I'm guessing that there's probably an average out there of what percentage of wages go towards union dues. Do you have a ballpark figure for me that you can offer?
Representative Nelson.
That would vary greatly for depend what type of, what the salaries are of the people, the workforce. I think I can't say that because I couldn't say. I know my carpenters union, they have a window dues that we pay for the carpenters, and when you're working, there's a percentage per hour that gets paid. But different unions operate differently, and I couldn't say what that percentage is.
Okay. Well, thank you, Mr. Chair and Representative Nelson. I took a look at what Massachusetts does in regarding to personal care attendants, and they charge a 2% on the wages that people earn. And if you look at what we're paying for personal care attendants, that is coming out to be probably about $8 million out of state tax dollars that would go then to the unions to pay for the union dues. Now, when you have 45% of the personal care attendants actually caring for their own relatives, maybe that's their son, their daughter, their parent, their grandparent, cousin, that means that that's money that's getting taken away from them caring for their own family member. $8 million out of the state coffers going to union dues, which was money that was intended to go towards helping care for these individuals. And I have grave concerns about that piece of the bill in particular. I have a lot of constituents that care for their children, care for their parents, other relatives, and their biggest concern to me is the money, the precious dollars that they get to help care for their relative now is going to go to a union, and basically you're unionizing them against their own relative, which kind of doesn't make sense. So I'm very concerned about this piece in particular of the bill. I'm also very concerned about the child care unionization of our daycare providers as being independent business owners. But I'm going to pause for a moment. I'm sure there's probably other people that have some questions. But that piece in particular and this language that you have in here and the fact that folks are not going to be able to opt out of this, that they are, can't keep their information private is really of concern to me.
Representative Holberg.
Thank you, Mr. Chair. And Representative Nelson, I can't remember where I heard the bill the first time around. I don't see that it went to civil, but maybe a piece of it came to civil. Could you refresh my memory?
Representative Nelson.
Looking at the thing, we did go to civil law on the PCA piece. And it was after it went to civil law, and then it got merged with the daycare piece. Okay. So it was 844 that we saw in civil law. And then it's been to labor, it's been to health and human services, it's been to early childhood and development, it's been to the labor committee, government operations, and then now we're here in ways and means.
All right, thank you. And if I might, I'm sorry, could you refresh my memory as to the right terms to use? There's I believe, a list and a registry associated with the PCA unionization proposal. Is that correct?
There's the PCA piece of it. They're creating a workforce council to create a list that DHS would have so that people who need these services would be able to have access to that list if they don't have a relative or a friend that's willing to do this for them, that then would be able to go to DHS and have people that are doing this currently and or wish to be doing this and are trained to do this, so that instead of having to go to Craigslist or put an ad in the local newspaper, that they have a place that they can go. The DHS would have a list of these people who are willing to do this. And again, that's an optional registry.
And, Mr. Chair, so Representative Nelson, that's not the list, that's the registry that when we were in civil law was going to be an opt-in if you wanted to be on a website, I'm available for hire as a PCA, call me or whatever. Is that correct?
Mr. Chair and Representative Holberg, yes, that would be the optional registry. The list is different from that. The list would be for the election purposes. And again, if the bill passes, it would create that workforce council with that optional list. The list that the DHS has would be used for the representational vote, and that's already subject to information request.
Okay, I appreciate that. So then if we can go back to the, I'm sorry, Mr. Chair and Representative Nelson, if we can go back to the A72 amendment starting on page 2, lines 34, where you start getting into some of the data provisions around this. What data does this language relate to? Is it both the list and the registry, or just the list?
Representative Nelson.
It's just the list.
And Mr. Chair and Representative Nelson, so the data that would form the registry would all be self-reported and would not be a subset of the list, is that correct?
Representative Nelson.
That's correct. It would probably be a subset of the list, because of the people that were on the list that asked to be on the registry would, but they're two separate things.
Well,
And it's strictly opt-in.
Representative Holberg.
well, Mr. Chair and Representative Nelson, the registry, if it is purely opt-in, then would they just, how would they know to provide the information? How does that process happen?
Representative Nelson.
Mr. Chair and Representative Holberg, I don't know the exact answer, but I would assume DHS would put a mailing out to these people and saying we've created this workforce council, and allow people the ability to put their name on the list,
And
on the registry.
Mr. Chair and Representative Nelson, so then somewhere in your bill you give the authority to DHS to contact these people and set up an opt-in registry, is that correct?
Representative Nelson.
Yes. Mr. Chair, it's on 11.8 of the bill.
11.18, okay.
11.8.
11, Mr. Chair and Representative Nelson, 11.8, thank you. And if I might, I'd like to really spend some time on the issue of the list. And we had a discussion around this in civil law and how if you are comparing these two groups, there's a vast difference in the public or private nature of the data sets, and that if you're a licensed child care provider in the state of Minnesota right now, the information about you is public, in that anybody can get that list. So if we have an organizing activity happening, those that would like to resist the organization efforts have the same access to the data as those doing the organizing. In the case of the PCAs, that's not the case, and we had this discussion in civil law where only the union would get the list from DHS. Have you made any attempt to balance that in your amendment here, your bill, so that other entities would have access to the same list of people to, if they wanted to organize to resist or oppose an organizing effort, they would have an equal opportunity to do that?
Mr. Chair, Representative Holberg, it goes the same way that it currently does under PELRA. It would follow the same rules as the current organizing any other organizing activity of somebody trying to organize a unit in government.
Well, Mr. Chair,
Representative Holberg.
and Representative Nelson, it's my understanding that if you were, say, trying to organize a store or a place of employment, they would be there all together, and the employer would have the list of the people within that, group. This is a very unique situation in that you have thousands of people scattered across the state and no ability to even know, who's even working in their same profession. So I'm not sure that there is a process for a vote no organization to take place.
Mr. Chair and Representative Holberg, it's the same challenge that anyone that had worked for the state of Minnesota, if there was a large bargaining unit out there of unrepresented workers, again, in the state of Minnesota, say MnDOT, they're organized, but if they were unorganized, it would be the same process. They'd be scattered across the state of Minnesota in different areas, and it would be the same challenges for both the union and people wishing to resist a union would have that same challenge in that situation as they'd have here.
Well, I'm not sure that I agree with that, but let's go to your supposed data protections in your A72 amendment. If you look at the cross-reference, that it'll be governed by one, well, first of all, you got the reference to Chapter 13.43, Subdivision 6, that it'll be treated the same as labor organization access to personnel data. Basically, there's no protection. It may be disseminated to labor organizations to the extent that the responsible authority deems that dissemination is necessary to conduct elections, notify employees of fair share assessments, and implement the provisions of Chapter 179 and 179A. And so if you're looking at data that's held by the Department of Human Services on PCAs, a lot of that information is about who they're providing services, the nature of their disability or condition. I don't see any protections for that information. I think a much cleaner way to approach this would be to provide a specific set of data sets, name, address, email, or whatever, and make sure that the private information of their clients or the people they serve is never made available no matter what.
Mr. Chair and Representative Holberg, the line that you read, 3.2, right after that said subdivision 6, this shall not include access to private data on participants or participants' representatives. So, I mean, that's in there, that they're not giving that private data out.
Well, I think, again, would you think that the location of where the individual worked would be available to the labor union?
Representative Nelson.
Representative, Mr. Chairman and Representative Holberg, it's names of address of the workers. Now, if the worker happens to live with the person that they're caring for, it's not identified that that's who they're working for, but that would give the address of where they're working. But the rest of the list would be just the people and where they live. It's the personal care attendants where they live, not their clients. But it could be their clients if they're living with that person, if it's a family member. But it wouldn't be identified that that's where they work at. It's where their home address is.
And, Mr. Chair, if I might, after they're initially contacted by the labor organization for organizing purposes, do they have a right at that point to ask to be not contacted again by that organization and to be removed from any of their databases?
Representative, Mr. Chairman, yes. They would be able to. That's their right to say, don't contact me again.
And, Mr. Chair, do they have the right to contact the Department of Human Services and say, do not give my information to the labor union?
Mr. Chairman, yes.
And Mr. Chair, Representative Nelson, where does it say that in the bill?
Mr. Chairman, there's nothing that prohibits that in current law. That would be, if they don't want to be contacted, they have the right not to be contacted.
Well, Mr. Chair, and Representative Nelson, when I read the governing statute in 13, Chapter 13.43, Subdivision 6, there isn't that right specified there. I'm just wondering where in current law an individual has a right to notify the State Department not to give out their information to labor unions.
Mr. Chairman, they have the right not to tell them not to contact me, and then I think the regular laws that we have, trespassing laws and all those would apply, that don't contact me, don't come back, those laws would apply.
Well, Mr. Chair.
These are the same rights I think any of us have.
Well, Mr. Chair and Representative Nelson, trespassing is different than get me off your mailing list and don't send me any more of your stuff ever again. So are you saying that that right is in PELRA to refuse to be a part of this process and opt out of a list?
Mr. Chairman, they have the right to opt out of that list. They have the right to tell them, no, don't contact me again.
Mr. Chair, maybe there's somebody in the audience that can tell us where that right is spelled out in labor law. Mr. Chair, I'm wondering if there's anybody in the audience that...
Mr. Chair and Representative Holbrook, it's the same right that any worker would have in any other organizing drive in the public sector, that to be able to say, don't contact me again. I mean, that's just a right we have. It'd be covered under the existing PELRA statutes.
All right, Mr. Chair, I'll try and find the information myself between now and the floor. I know you probably want to get this amendment on. I think there's lots of questions about the bill itself, and I'll just...
Okay. There are three people that have indicated they want to comment. Is that on the amendment or later on the bill? Okay. Was it on the amendment or on the bill?
I believe it's on the amendment.
Okay.
It has to do with, thank you, Mr. Chair, it has to do with fair share workers' rights following the election and the certification. The first question is, is that worker eligible and able to freely attend union meetings of the bargaining unit? And secondly, is that fair share worker entitled to the terms and conditions and benefits that the bargaining unit negotiates?
Representative Nelson.
Mr. Chair and Representative Ansel, a fair share in any union, not just these people here, in a fair share situation, the member is not entitled to vote in contracts, is not entitled to attend meetings, but if they have an issue, if they file a grievance, if they have issue where they need representation, the union representative is required to represent them. That's what the fair share dues go for. They get full benefit of all contract provisions, that wages, benefits, the whole lot. If those are negotiated, they would get full benefit of that. But because they don't want to be a member of the union, they don't have the right to vote on who represents them, and they don't have the right to vote on the contract once the contract is done. But otherwise, if any provision in the contract, if there's a dispute over the contract with their employer, if there's a dispute over the contract with, or they need to file a grievance, the union is required by law to represent them, and that's again what the fair share dues go for.
Okay. The chair renews this motion. Then we're to adopt the A72 amendment as amended. Any discussion? Seeing none, then all those in favor signify by saying aye.
Aye.
Opposed, motion carried. Okay, we have in your packets, members, the A80 amendment. This is the appropriation section, so the chair moves the A80 amendment, and this is based on the fiscal note that's in their packets that we received literally this afternoon. So any discussion on the amendment? Seeing none, then all those in favor signify by saying.
Mr. Chair, can you tell us, we've been spending money the last week here in this committee off the bottom line. Can you tell us what's left after this
There
is
is.
accounted for? I asked Mr. Marks for an updated sheet, but I think he's still snowbound.
He's
So
snowbound. I can tell you this, that we haven't cashed out, and this bill was actually built into our projections at a higher number, and the fiscal note came in lower than what we expected. I know Mr. Berg is sitting in tonight on this bill, but I don't know if he has the big picture.
Mr. Chair, you'll have to wait for Mr. Marks.
Oh,
for that.
Ms. Conley said she can get it as to where we stand currently.
okay, I would appreciate.
And the other one that came in less than expected is the pension bill.
Great, thank you,
So
Mr. Chair.
between this one and the pension bill, and then at one point, before we took up the pension bill, we were down to about $2.5 million on the bottom line. And this one coming in less, and the pension bill coming in less, we're now above that 2.5. If you need more information, we can get that.
Oh, yeah, and Mr. Chair, I can wait for Mr. Marks tomorrow as well.
And my recollection was the pension bill was significantly below what we had anticipated by something like 10 or 15, about 15 million. We're at 17, well, that would be about right then, the 15 plus we had the 2.5, this one is a little less, so we're somewhere in that general range.
All right, thank you.
Okay, any further discussion on the A80 amendment? Seeing none, then all those in favor signify by saying aye.
Aye.
Opposed, motion carried. We now have the bill before us as amended. Any discussion? Representative Dittmer.
Yes, thank you, Mr. Chair and Representative Hanson.
Nelson.
Nelson, I'm sorry. Long day here.
There's several of us with our SONs, and we do get mixed
He's better looking than I am.
up. So.
Thank you, Representative Nelson. Under current law, doesn't child care providers, don't they have the option to join unions now? And if they, under current law?
Representative Nelson.
Mr. Chair and Representative Detmer, under current law, they do not have the right, and that's basically what this bill, both the bill does for both the PCAs and the child care workers that are working in home health and home child care. They currently do not have a right to organize, and this is allowing them a right to be able to try and organize and get to an election and vote on whether they want to be or not be union. That's what the bill does in its basic form. And if it gets to an election and the election goes the wrong way, in my mind, and they lose, they won't be represented. But they at least have the ability, the bill is giving these two groups of people that ability to try and form a bargaining unit and get to an election and form a union. Right now, there is not that right in current law.
Mr. Chair, Representative Nelson,
Representative Dittmer.
Now will everybody get a chance to vote? Every child care provider get to vote, regardless of how big they are, how small they are? Does everybody have a vote on this?
Representative Nelson.
Mr. Chair and members, the nexus or the group that's being held together here, it's the people that get, for the child care side of it, it's the people that get CCAP dollars. And I liken it to, there's been a lot of people saying, well, I don't take CCAP dollars. I never have taken CCAP dollars. I don't want to take CCAP dollars, but I want a right to vote. And I liken that to taking, if a union was trying to organize Walmart and you had workers working for Target, Those are two workers essentially working for the same type of corporation, doing the same type of work. But if we're organizing drives going on for Walmart, that the workers from Target wouldn't be able to vote on that contract or vote on whether they have a union or not. They're two separate groups. The group here we're using, the nexus that they're using to tie these together is the CCAP dollars. And so if the people that get CCAP dollars or take children that get CCAP dollars are the ones that would be able to vote on the union.
Mr. Chair, Representative, what are the numbers? What kind of numbers of providers are we looking at here? Those that you have licensed family child care providers and you have the unlicensed. What kind of numbers are we talking about here? Is there a small group going to be allowed to vote for a larger group of providers?
I believe I'm trying to find the email I was sent yesterday with those numbers. And I believe it was like 35% of. It's about 11,000 statewide. I'm trying to find the email here I was given. Here we go. There's about 10,778 licensed daycare providers in the state, and roughly 35% of them take CCAP children. And there's approximately, what was the number here? Okay, there's approximately unlicensed daycare providers, about 6,000 of those that would be eligible.
Mr. Chair and Representative Nelson. So you're talking about 35% of the people, child care providers, will be voting for the other, 65%.
Mr. Chair and Representative Detmer, the people that are voting are the ones that get the CCAP dollars, and the ones that don't get the CCAP dollars, don't take children with CCAP dollars, would not be in the bargaining unit, and they would not be required to join the union, and they would not be required to pay fair share dues if they chose not to join the union, because they would not be included in the bargaining unit. It'd be like I said, it'd be like you have Target and Walmart here. The ones that take the CCAP dollars would be the Walmart employees who are being organized. The ones that don't take the CCAP dollars would be the Target employees, and they would not be party to the union. They would not be required to join the union. They would not be required to pay fair share dues if this Walmart group were to get organized.
Thank you, Mr. Chair.
Okay, we have Representative Anderson.
Hi, thank you, Mr. Chair. And Representative Nelson, kind of along the same lines of what Representative Detmer was asking here. Tell me exactly what will be the responsibilities of the union if they're formed. What exactly will they do that, one, isn't being performed by the trade association for the daycares currently, and two, what happens? Are they going to be, and this is more particular, tell me if they are directly going to be impacting what the regulations will be on daycare providers. Is that what their kind of intent? Will they be negotiating that with the state, kind of the guidelines of how to care for children? Is that what's going to be part of their organization?
Mr. Chair and Representative Anderson, that would not be part of what they're doing. They may have a voice in that. I mean, the idea is to help the daycare providers that are in the union to have a more united voice when they come and talk to the state. But they would not be. They would be just one group of many that would be doing that. What the people in the union in the bill says is they'd be able to meet and negotiate with the commissioner about the possibility of getting training, a possibility of getting better conditions, better pay, better benefits. Those are things that they would negotiate for, and they would meet and negotiate with the state on those issues. But that would not preclude, and the issue, like you said that you mentioned about regulations and that would not preclude any other group that either licensed or unlicensed daycare providers that don't take CCAP dollars to be able to do that also with the state.
Mr. Chair and Representative Nelson, what better pay, what better benefits when this is these are independently owned businesses that set their own rates. How are they going to be able to do that? Can you explain that a little bit more for me?
Mr. Chair and Representative Anderson, through attempting to get better child care reimbursement rates for the CCAP participants.
And Mr. Chair and Representative Nelson, what percentage will the union take out of that better pay and better benefits? Can you tell me what dollar figure that we're looking at that would go directly to the unions then?
Mr. Chair and Representatives, it would be, again, the union dues that would be charged if a union was formed would be based on what the members vote on. So they would have a direct democratic vote in that, what the dues are set at, and that would be that. It wouldn't be any higher. If it was a percentage and they got a better return or better reimbursement, the dues might go up if it was based on a percentage, but if it was a straight dollar amount, they would not get any more. I mean, you're throwing numbers out there that it's billions of dollars that they're going to siphon off from the state, but that's not the way I look at it. You get benefit from your union dues and you get benefit from your representation.
Mr. Chair and Representative Nelson, you just mentioned that if the rates were to go up, that the union might raise the union dues that are owed to the union based upon how well they're able to negotiate. So that's something that we could anticipate seeing happening, or?
Mr. Chair and Representative Anderson, I said that if it was based on a percentage of the CCAP dollars, whatever I don't know how the dues, because there isn't a union now, they haven't set dues. When the union gets certified, they would then set their own dues. But if it was based on a percentage of the CCAP dollars and they got a raise in the CCAP dollars, a raise in the dues would follow. Just like if your dues are set on a percentage, that's how it would work. If it's set as a straight dollar amount per month, it wouldn't affect it at all. If they got more money, a higher CCAP reimbursement rate, it wouldn't affect that at all.
So, Mr. Chair and Representative Nelson, the more money that's put into CCAP, then the more money the unions get. If it's based on a percentage, correct?
If it's based, Mr. Chair, if it's based on a percentage, it might. But dues are again voted on by the members of the union, and that they set their own dues.
And Mr. Chair, Representative Nelson, how much do we put into the CCAP program now?
Mr. Chair, I don't know that figure.
That might be.
Mr. Marks, for.
We'll have to check on that. Apparently,
Okay.
Mr. Berg, the fiscal analyst, said he'd need to check on that.
And just a couple other questions, Mr. Chair, Representative Nelson. So, as I understand it, this bill says that for CCAP, if you were in CCAP in the last year, then you would be lumped into the union if the folks vote for a union. Is that correct?
Mr. Chair and members, if you were in a CCAP in the last year, you would be part of the people that would be able to vote whether you wanted a union or not, and then all the other things that we're speculating about here then would happen if a bargaining unit was formed. But this bill, the only thing this bill does is allow these people who wish to try and form a bargaining unit or a union, gives them the opportunity and the ability to do that. And everything else after that is speculation. What the dues are going to be set at and all that, that would come after the election. This is, again, about allowing these people to vote. And you've got two groups of people here. We've got a group of daycare providers that have approached the union and say, we want to do this, help us do that. And so they're trying to do that. And they want the ability to be able to vote to whether they want to have a union or not. And you got a group of people that don't want a union, don't want anything to do with union, but they don't want to let these people even have the ability to vote on it. And so what we're talking about here, members, is allowing people the chance to vote or blocking everybody from having a chance to vote. And that's the the simplest version of what we're trying to do here, is allowing people who have said that they have an interest in trying to do this, the ability to vote on whether they get to have a union or not.
Well, Mr. Chair and Representative Nelson, I'll just say this and let other folks ask some questions here. My concern is I had the opportunity to sit down with daycare providers in my community, and their concern is that if this union is formed, that they have no vote on, there is going to be this group then that will be negotiating what happens in daycares, what kind of regulations that they have, how they have to handle the children. And then they have no option, they have no voice on this because, one, they didn't get to vote on the unionization at all. And in order to have a voice, they'd have to join the union. And it puts them at a huge disadvantage. And without, stating the obvious here, basically what we're doing is we're taking CCAP dollars that were put in place for the purpose of helping folks pay for child care, and we're funneling that money now to pay for union dues. And I have serious concerns about what that means for these families and the potential that it has to dry up child care across the state of Minnesota. Now, it may not be a big deal here in the metro area to maybe lose your daycare provider that you've had for the last 3 years, because you probably could find another one down the road. But when you're out in greater Minnesota, where daycare is hard enough as it is to be able to find, you're going to be drying up more opportunities for these folks to find care. And I'm very concerned about that. I have my son in child care right now, and it's not easy to find the right fit for your kid. And here we're going to be limiting options for parents that are struggling to make ends meet in the first place. Plus, we're directing precious dollars that are meant for the care of their child to union dues. So I'm very concerned about this.
Hey, Representative Mahoney.
Oh, thank you, Mr. Chair and members. I mean, Representative Anderson, you've slyly slammed unions every time you could possibly do it. First, you said unions are organizing against something. Unions don't organize against anything. They organize to represent the people who work. Plain and simple. They're an organization for the fraternal brotherhood and sisterhood of the members. They're not organized against something. And I want to tell you, I'm a union member. I go to my union meeting at least 10 times out of the year, out of the 12 meetings. And at every meeting, we have a financial report of the finances that were spent that month, what's left in the bank accounts. We know exactly where our dollars are and where they're going and what it costs to run my union. And every year, or every 2 years, or every 3 years, they bring it up for a vote. Should we spend another $5 a month in union dues, or should we not? I get that vote when I'm there, and I write my yes or no on my sheet of paper, and I put it in a ballot box. It's a very democratic process. And to take money from CCAP? No. These union dues are paid out of wages that are paid to the provider or to the provider's employee. They're not money taken out of CCAP. These are wages earned by these employees and by these daycare providers. So we're not taking, or this particular union or any other union is not taking money away from an organization or a state. It is taking the wages that are democratically are earned and then are democratically decided to where they should be spent. So your argument is pretty slanted, but it's pretty false.
Thank you, Mr. Chair. I appreciate it. And Representative Mahoney, this isn't an attack on the unions at all. In fact, my husband belongs to a union. So this isn't about that at all. The issue here is that at the legislature, we allocate funding for CCAP, and we allocate funding for the PCAs, for folks to be able to take care of their own relatives. It's not about having this money go to union dues. The whole purpose is to be able to give these folks the resources that they need to pay for care. And the intent was never to have that money to go towards union dues. And here what we're doing is on the PCA alone, we're going to be looking at $8 million that could be going towards helping people care for their relatives or whoever they're working for. Now is going to be funneled towards union dues rather than actually caring for people. And the same goes for the CCAP program. That's meant for money to be caring for kids, not for union dues. And that's the issue that we have here today.
Mr. Chair?
Representative Mahoney.
You know, actually, I thought if you're a PCA, you were getting wages. You were not getting an appropriation in a bill. There's no earmark, no anything else. It's wages that that particular person earns. So now all of a sudden they don't get to do what they want to do with the wages that they've earned. You know, I think somebody was accusing my side of the aisle of doing some of that a little earlier. And it is. It's just wages, and if they make the choice, and it's whether it's 35% or 55% of the PCAs or the child care providers that that are in this particular bargaining group, they're using their wages. They're not using taxpayer dollars. They've actually gone to work, they've cared for that person or that child, and they've earned their wages. They can go out and spend it on groceries, they can spend it on car payments, they can spend it on union dues. I'm not sure where you're going with this argument about tax dollars going to a union, unless you've got some magic that the laws have changed and the laws of economics have changed. If I've got a paycheck, I get to spend it whichever way I want.
Well, Mr. Chair and Representative Mahoney,
Anderson.
these child care providers are independent businesses. They are not employees of the state. Okay?
And they
So
get wages from, they get wages
this money is meant to go for the care of these kids, meant to go for the care of folks that need personal care attendants, not for union dues.
I think we'll,
And Mr. Chair, again,
Representative Mahoney, and then you're done.
what
You're
am I missing here? I mean, they're paid wages. They are paid wages to care for someone, and if they choose to spend it on Twinkies or hamburgers or union dues, I mean, I'm not quite sure where you're coming up with. So long, if the state has allotted that money, it is still the state's money. If those people have actually done a day's worth of work, it's their money, and they get to choose to do what they want with it.
Representative Mahoney, I would add that they also pay taxes on it.
Oh, that's true, too.
Yeah, I mean, in the sense that it's their dollars,
Yeah.
and they're subject to taxes. We have, let's see, next, Mr. Byrd, you've got the number that we were looking for.
Mr. Chairman, Representative Anderson had asked how much CCAP spending was. Just quickly looking, fiscal year 12, there was $109 million in payments for the MFIP and transition year child care assistance program, and $94 million in the basic sliding fee child care assistance program.
And now we have, let's see, Representative Dean is next, I think. Representative Dean.
Thank you, Mr. Chair. Representative Nelson. Since the Health and Human Services Finance Committee, I, like Representative Anderson, have had an opportunity to meet with child care providers in my community. And Representative Runbeck, Senator Chamberlain, and I contacted members of our districts who are child care providers and invited them to attend a meeting. And folks from the union also came. And it was a very good exchange that we had in an opportunity for them to ask questions kind of each other, and it was a very, very productive meeting. And I have a couple of clarifying questions from our earlier conversation with specific respect to the relationship between the money provided for the services and the contractual relationship with the union. But before I do that, I just want you to go on record and let the committee know whether or not you agree with Representative Mahoney's representation of how the dollars flow directly through the state of Minnesota to the union member. Is that your understanding, the way that Representative Mahoney just described the process? Is that your understanding of how the bill works?
Mr. Chair, Representative Dean, Representative Mahoney talking about once the wages, once the CCAP dollars, whatever you want to call it, once they are earned by the individual, that's their money. And like in all our public employee unions, we give them the ability to have dues check off. or if they're, the law, Pelra law requires, if you're not in the union, requires fair share dues be taken out of the money you're getting from your employer. And so once the money is earned, it's your money to be spent the way you choose to spend it. And if the union gets formed and they vote to form a union, paying their union dues would be part of their money that they're spending for their union dues. And again, we have provisions in state law currently that cover this under Pelra, that union dues can be deducted by the members from their paycheck that they get from the state, and the fair share dues can be deducted from the members that choose not to join the union, and they're required to be taken from their paycheck from the state.
So it is your thank you, Mr. Chair and Representative Nelson. So it is your understanding that the current relationship between the state caring for and providing child care assistance for low-income children is going to be changed, and that the first obligation towards those dollars is now going to be towards contractually given over to employees and not children. Is that fundamental change your understanding of how your bill would operate, or am I misunderstanding the current relationship that we have? Because from my understanding, when what we are paying for is we are giving, the state of Minnesota is helping low-income families provide child care by providing dollars that go directly for the care of that child, not wages to be given to employees to be spent perhaps within that portion of business or elsewhere. So that's a change, and if it is a change, then I think that it's an interesting one that we should talk about, but it is a change from the way that the bill has been represented from the committee process to right now and moving forward. So I think if Representative Mahoney's representation of how this is going to proceed is correct, then we have a change, and I think that that's a substantive one. But if you agree with that, then that's, I guess, how we're going to proceed forward.
Mr. Chair and Representative Dean, for the group that gets CCAP, and they're going to have limited rights under Pelra 179, Chapter 179, and the money, the CCAP dollars follow the child, and once the CCAP dollars are given to the daycare worker for taking care of that child, that is money that they have earned. You can call it wages, you can call it the normal paycheck, you can call it whatever, but once it's earned, that is not the state dollars anymore, but the money follows the child, and then it goes to the daycare worker, and once it goes to the daycare worker, it's no longer the state's money, it's that daycare worker's money. And if those daycare workers vote to and choose to have a union, then they can direct how that money comes to them and gets paid back to for their union dues. And that's similar to all the other bargaining units that we have in the state of Minnesota. And this would be a limited bargaining unit for very specific purposes for the state of Minnesota.
Thank you, Mr. Chair.
Representative Huntley.
No, I'm sorry.
Well, Mr. Chair and members.
Oh, excuse me. Were you not done?
No.
Oh, excuse me. I thought you were.
Okay.
Yeah, Representative Dean.
Sorry, Tom.
Maybe it was the way you're facing directly.
Yep, I'm sorry. I have my back. Yeah.
I thought he was done too, but yeah. But anyway.
Representative Dean, go ahead.
No such luck. Sorry. Well, I think that that's a fundamental change, and it's one that many of us have a great deal of difficulty and problems and issues with moving forward. I think that it's a very good discussion that Representative Mahoney has brought forward, because here we are directly pivoting, very directly so, towards taking, as a public policy, taking dollars that are meant to pay for, at first, the first obligation is the care of a child. We are now saying that the first obligation is towards payment for union dues and for that time. That's a significant change. It's a policy change. I'm glad we've got it on record in the committee here moving forward. Secondly, I'd like to talk with you a little bit about the election process itself. And it's just because I wasn't listening carefully enough when you told me how many people have CCAP dollars, what the threshold for the vote will be, because when I talked to the daycare providers in my district, many of them had canvassers that were trying to get them to knock on their doors and call them, what that number is. So what's your total pool number? And then I'll have another question, Representative Carlson. But what is your total pool number, and what is your hard head count that you need in order to trigger the election from that pool?
Representative Nelson.
Mr. Chair, and again, based on the numbers that I've been given of the number of providers, licensed daycare providers of just under 11,000, and 35% of that, if we use 10,000, we're talking 3,500 workers. If it's, and then on top of that, you have the 6,000, I think, unlicensed daycare. So you're talking 9,000 some daycare providers out there that would be given a chance that there's a 10% trigger to get to an election. So you're talking 900 people would have to sign cards to get to an election. That's the minimum that they'd have to sign. Just to put on the record, any daycare, any union organizer that's going to go out there and organize, they're not going to go and call for an election if they only have 10% of the cards. Because if they only have 10% of the cards and they call for an election, the consequences when they lose the election are large. They have to walk away and not talk to these people for a minimum of a year before they could start another organizing drive. So they're not going to do that if they only have 10% support in the group, because they're not going to waste their time, and they're not going to try for an election when they don't think they can win. I mean, it's just like we all do that. We all count votes when we have bills. We all count votes when we go for election in our offices, and we know that if we don't have the votes there, we're not going to win. And they're not going to go for an election because the consequences for them and when they lose an election are large, and then it makes it more difficult the next time they try and do that. They're not going to do that unless they think they have enough to win. So 10% is where that is the bottom end that could trigger an election. They're not going to do that with only 10% support.
Representative Dean, when I passed over you, I did the same thing to Representative Mahoney the other day, so I'm quite bipartisan in assuming people.
I know.
Representative Dean.
I should have turned around. I apologize, Representative Kellerson. And just finally, I think that that's an important issue to bring up, that the forced unionization by executive order that was found to be illegal by the Supreme Court from Governor Dayton last year was turned back to the legislature. Here we are. And now we are lowering the threshold for votes. The head count that we need is fewer than 1,000 positive votes to trigger this election statewide, which I think is stunning, that it is that small a number, fewer than 1,000 positive votes in order to trigger an election. Moving that ahead, I think, is very, very significant, as one that the committee should take a lot of time in thinking about and moving through. But Representative Nelson, the thing that I want to just convey to you as you move this to the floor is something to relay something from my district. That we had the canvassers there, and we had the daycare providers in the room, and they were kind of like, staring across the room at each other. And I said had everybody introduce themselves, and I said, well, what are you asking for? I said, here you got 20-some daycare providers. Let's have your pitch. What is your pitch at the door? You got them all here in one spot. You don't have to go door to door. Let's have the pitch. And they said, what do they want? We want to know what they want. We can't tell you what we're going to offer them. What services will be provided that will help their daycare, which will provide better services to children. We don't really understand until we hear from them. And one of the daycare providers, do you know what she said? She said, we don't want anything. We want to be left alone. We want to be able to do our business.
No.
And that's the response that was given from my district. And what would you say to that mom who's trying to struggle and
just sort of hang on. She understands that that the CCAP dollars are tied to her business. She's probably going to vote no if she has this opportunity, but others won't, and this will move forward. Those dollars will flow through. She will be a de facto employee of MMB. She doesn't want this. What do you have to say to her? What better, what positive thing can you say to my constituent that was unable to be represented by the union at the meeting in my district?
Is that, Mr. Chair
Representative Nelson.
and Representative Dean, as I said earlier, this is about allowing, there's a group of providers out there that have said they want to try and form a union. This is about allowing them to try and form a union. If there's no support out there, and I've heard that thrown at me in just about every committee, if there's no support out here, they won't be able to get 10% authorization cards signed. And if they do get 10% authorization cards and foolishly go to election with only 10% support, and they have a vote, there will not be a union formed, because there won't be, if that's what they're saying, nobody wants it, there won't be enough people voting yes to have an election. And the election will be done by the BMS, following current procedures that they use for all representation elections. And so if there's no, number one, if there's not enough support to get 10% cards signed, and everyone's saying there's nobody wants it, they won't get the 10% card signed. So they won't be able to trigger an election. And if they do get 10% cards signed and they say there's nobody wants it, they won't win the election. And so there won't be a union. And then the only thing that will come out of this bill will be the Workforce Council for the PCAs that will be formed, and the optional list that will be created for the PCAs, so that people who need that services will be able to have a better way of getting that and getting people that are qualified. And there won't be unionized daycare, and there won't be unionized PCAs.
Thank you, Mr. Chair.
Yeah, Representative Huntley.
Mr. Chair and members, it's been said that the CCAP dollars are only to be used for the child care. They're not intended to be used for anything else. They come out of my budget in Health and Human Services. As Mr. Berg said, it's about $200 million. Let's talk about another batch of money in Health and Human Services. Medical assistance, about $5 billion. And that is designed for the same thing, is to take care of the health care of people, including kids. Now, where does that money go? Some of it goes to hospitals. Some hospitals have unionized nurses aides, unionized janitors. Some hospitals don't have any of those unionized. We don't care. What we're interested in do they take care, in the case of hospitals, do they take care of the patients? Many nursing homes are unionized. There again, it's not my job to say whether they should have a union or not have a union. It's my job to say, is this money being well spent in getting the care that these people need? And it's the same with the child care system. If they choose to unionize, that's their business. Whether it's CCAP dollars or whether it's medical assistance dollars, it makes no difference. Does the money get the care that these people need? Who delivers that care, whether they're unionized or not unionized, is not my business.
We have three more people on the list. Representative Goldberg, you're next, but did you want to do the concluding comments, or
That's
just
fine.
take it in order?
I'll wait.
Okay, then that would be Representative Mahoney.
Thank you, Mr. Chair. And Representative Dean tried to imply that the first thing off of a paycheck or these dollars coming from CCAP or anyplace else would be to a union. I don't know about anybody else, but the last time I looked at my paycheck, the first thing was the federal tax and the state tax, then the Social Security, and I think Medicaid or Medicare, whatever it is, and then a couple other things. And, I've had dues check off on my paycheck when I was working with the tools, and that was typically the seventh or eighth thing down the line. So I typically, most of the time, always considered when I was working for somebody, I was working for myself, and the contractor just paid me for being there and doing a good job. And first thing off the check was taxes.
Okay, we have Representative Nornis.
Thank you, Mr. Chair. And Representative Nelson, when I bring a piece of legislation to this body, I generally try to have a larger group supporting me as possible. And I tell you, to be honest, where I live in my district, I can't find a single person who wants this. So that's just the statement. Now, the question is, these cards that you're circulating, are you going to circulate any of those in greater Minnesota, or are you going to concentrate in the Twin Cities?
Mr. Chair and Representative Nornis, I believe if I was the organizer for the AFSCME union that's going to try and do this, I would do it all over the state. I would try and contact people in greater Minnesota, in the metro area, to get the most number of cards possible. And if I was doing it, that's how I would do it. And so I would say, yes, they're going to be doing a greater Minnesota, because it's going to be a statewide union.
Okay, Representative, what I think I will do is Representative Holberg would like to make the concluding comments and or questions, and then we'll ask the author to wrap things up, and then we'll go. Representative Holberg.
All right, thank you, Mr. Chair. And Representative Nelson, as other people ask questions, I have a couple more things that have come to mind. Can you tell me, under current law, and if the vote to form a union for daycare providers and or PCAs are successful, will they have the right to strike?
Mr. Chair and Representative Holberg, it's specifically in both instances, both of these groups have said they do not want the right to strike. They want to be considered classified employees. Is it classified essential employees, thank you. And they want to be considered essential employees because for the daycare people, they're taking care of people's kids, and sometimes in cases their own kids. They don't want to be going on strike against these families. And for the PCAs, they've said the same thing. They're taking care of people that they care deeply about, and they don't want to be forced to go on strike. So it's specifically in the bill in both sections that they do not have the right to strike.
Sure, thank you. And then if I might, I may have misunderstood your numbers, but maybe you can help me with this, with your 10,788 licensed child care providers, and then you thought that there was about 6,000 unlicensed. Is there information available publicly, or will these 6,000 unlicensed child care providers, will it only be the organizers that will have an opportunity to contact these people?
Mr. Chair, Representative Holberg, I believe that would follow the same PELRA regulations for conducting a representation election.
Well, Mr. Chair, that's not my question. If you're a licensed child care provider, you're 10,778, that information is public information because you're a licensed child care provider. This is the first time I've heard about the 6,000 unlicensed providers. Are those 6,000 unlicensed providers, is their data available to people that want to organize Vote No, or will only the union have access to that list?
Representative Nelson.
Mr. Chair and Representative Holberg, I'm being told that all the lists are public.
Okay, thank you.
For the child care providers, licensed or unlicensed.
All right, great, thank you. I appreciate that clarification. And I heard you talk about the 10% threshold, and that the union would not be smart to conduct an election with only 10% of the cards. And so I'm really curious why you didn't choose the 30% standard that's in current law that everybody else has to meet. And in fact, I believe the Senate bill also has the 30% standard.
Representative Nelson.
Mr. Chair and Representative Holberg, they're split across the state. The reason for the threshold in the first place is to prevent frivolous elections. And so with these people spread as they are across the state, and then the PCA side, some of the list isn't as good as the daycare side. The list is on the website. in fact, some of the opponents of the bill who earlier wanted me to make that list private are using that public data to gin up people to say they don't want it. So, I mean, that list is out there. But because of the nature of how they are spread all the way across the state and every corner of the state, it's a 10% number. If you're talking about a target or a plant that everybody's all in one place, that's more like a 50% threshold that you'd have to reach. So, I mean, it's going to be a hard job, even at 10%, to get enough cards signed in the time period that they're allowed under PELRA to do that. I mean, from when the bill passed and the election started on October 1st, they'd have 6 months to gather those cards and get the ones they needed to get to an election. That's going to be a Herculean task for them to do. And so 10% for this type of organizational drive is a large number. And again, no union organizer worth their salt would go to an election without believing they have the majority of the people. So they're going to have a lot more than 10% of the authorization cards signed of this list of people than if they ask for an election. And again, there's a lot of ifs there, because it's all based on if the bill passes and if they get to that point and if they have an election. All this bill is really doing is allowing these people the chance to try to form a union, and that's all they're asking, is to be able to have the ability to try.
And Mr. Chair and Representative Nelson, I think that part of the opposition to this is all the exceptions. This is not a normal situation. You're not organizing a factory or a workplace, and so when they see that the standard in law is 30%, but you're only willing to rise to a 10% standard, that makes people really nervous. And when only one side of the equation gets the complete list and the other side gets no list at all, that's not an even playing field. And I think in some ways it really, makes people angry. I sent out letters to every licensed child care provider in my district and explaining my position and concerns with this bill, and I was not contacted by one person that disagreed with me. But just if, in fact, let's say I'm a child care provider today, and I don't want to be part of a union, and so from what I understand, the only way to not be part of a union is to not have CCAP kids. If I had a CCAP kid in my home today, and if I felt more strongly about the union's possible negative impacts on my business, and I asked that person or helped them find another provider, because I was a CCAP provider within a year of this deadline, would that make any difference, or would I be forced to be a fair share person by virtue of the fact that I had a CCAP kid in my home today?
Representative Nelson.
Mr. Chair, and again, under PELRA, if you're in the bargaining unit, if you choose not to join the union, you would have to pay the fair share dues. If you choose to join the union, you pay the full dues, whatever those were set at. But if you're in the bargaining unit, and again, this is PELRA law, if you're in the bargaining unit, you either can join the union or you can choose not to join the union, but you'd have to pay the fair share dues.
Well, Mr. Chair, Representative Nelson, I don't really care about PELRA. I care about your bill. And from what I understand, correct me if I'm wrong, if I don't have CCAP kids, I never can be forced to join the union. Is that correct?
Representative Nelson.
Mr. Chair and Representative Holberg, if you don't have CCAP kids and you don't ever take CCAP kids, you would never have to join the union.
Okay, but when you were explaining your bill, you talked about if you had CCAP kids now and the timing of the election. I'm asking you, under your bill, if I have a CCAP kid in my daycare today, is there any way to avoid being part of the union either as a member or fair share, or is it too late?
The
Nelson.
Representative, Mr. Chairman and Representative Holberg, the bargaining unit, and again, that's what I'm talking about, PELRA. That's existing PELRA law dealing with representational elections. If you currently take CCAP kids, you'd be part of the bargaining unit that would be get the ability to vote yes or no, whether you want a union at all, and then if it did get formed, you'd have to make the choice of whether you wanted to join the union or be fair share. But if you're in that, if you're getting CCAP kids, you would have taken CCAP kids, you would be the one being able to have the vote whether you want to form the union or not. And you'd be given the election information, and you'd be given a ballot to vote yes or no. And you can vote no, and if you vote no and there's not enough 50%, more than 50% that vote for the union, there would not be a union, and you wouldn't have to join any union.
Okay, Mr. Chair and Representative Nelson, what is the cutoff date for not having CCAP kids to avoid being part of the election or fair share or anything? At what point would I have had to have stopped having CCAP kids to not be put into this category of providers?
Representative Nelson.
Mr. Chair and Representative Holberg, it would be 12 months? 12 months prior to whenever they filed for the election. So if they filed for the election, if they were able to file for the election on October 1st, it would be 12 months prior to that. If they don't file for an election till next July, then it would be 12 months prior to that.
So, Mr. Chair, if I had a CCAP kid in my daycare today, and I said, I am more afraid of what the effects of being a union provider would be, than my commitment to this individual child. If that didn't happen before October 1st, there's a good chance that no matter what I wanted, I would still be, if the election was successful, I would force to be a fair share provider and have no way out of it. Is that correct?
Representative Nelson.
Mr. Chair, you'd be in the bargaining, if the election were filed for the 1st of October and you're currently taking a CCAP kid, you would be eligible to be part of the bargaining unit, you would be in the bargaining unit, you'd be eligible to vote yes or no, and you'd have that right to be able to vote no.
All right. Well, Mr. Chair, I think there's really a lot of concerns with this. My email's filling up. I think it's really unfortunate. One more question. If I am a low-income parent and qualify for CCAP money, can I spend my CCAP money in a non-organized child care, or will I be limited to a small subset of the total child care choices out there?
Representative Nelson.
Mr. Chair and members, the CCAP dollars follow the kid, and so if you were to take your child and go to another daycare person, that person would then become part of the bargaining unit because they're taking the CCAP dollars.
Right.
So the nexus that ties the people together is the CCAP dollars.
Right. So,
And if you stop taking CCAP children, you would drop out of the bargaining unit and you would no longer be in.
so basically, I guess what the situation we have here is that low-income children are going to be limited in their choices of what child care providers their parents can choose, so it won't be the best fit or best option of all choices of child care available to them in their area. They will only be able to choose from organized child care providers in their area or forego any of the money. Won't that be their choice? No state money or a union child care.
Representative Nelson.
Mr. Speaker, or Mr. Chair and members, if you put it that way, I guess yes.
All right. Thank you, Mr. Chair.
Okay, Representative Nelson, if you want to have any concluding comments.
Mr. Chair and members, again, both half these bills, and we seem to be spending most of the time on the child care piece of it, but both half these bills, it's simply about giving a group of individuals, and the child care providers or PCAs, the ability to try and form a union and try and have a vote. And if the bill passes, these people will be given the opportunity to try and form a bargaining unit, and they'll be able to vote on whether, if they get enough they meet the threshold and they get to that point, they will be able to vote on whether they want to have a union or not. And that's what this is about, is giving people the choice of whether they want to be in a union or not.
Okay,
Mr. Chair, I'd like a roll call on this,
roll
please.
call has been requested. The chair renews this motion that House File 950, the fourth engrossment, as amended, be recommended to pass and placed on the general register. And we'll start the roll call as soon as you're ready.
Carlson?
Yes.
Abler, excused. Anderson?
No.
Ansel?
Yes.
Atkins?
Yes.
Beard?
Nay.
Reinhardt?
Yes.
Clark, excused. Davids?
No.
Davney?
Yes.
Dean? Detmer?
No.
Gunther? Hackbarth?
No.
Hausman?
Yes.
Hillstrom?
Yes.
Holberg?
No.
Hornstein?
Yes.
Huntley?
Aye.
Hahn?
Yes.
Linchewski? Loon?
No.
Mahoney? Mariani? Markwart?
Yes.
McNamara?
No.
Mullery? Excused. Nornis?
No.
Hamar?
Aye.
Pulowski?
No.
Poppy?
No.
Simon?
Yes.
Wagenius?
Yes.
Woodard?
No.
Gunther?
No.
Okay, the ayes have it, 17, the nays 14, so the motion prevails. Thank you, Representative Nelson, and those in the audience.
Thank you, Mr. Chair, and thank you, committee
We'll meet
members.
on Monday, members, and we'll be taking up the Winkler campaign finance bill and the Mahoney workers' compensation bill. 10 o'clock, room 200 on Monday. With that, meeting adjourned.